Get ready for dictation at the rate 80 word per minute. 3, 2, 1, start. Learned counsel for the appellant argued his case and submissions were made by him. Full stop. We may make it clear that the outset that none of the appellants belonged to the category of either SC/ST or ex-servicemen, and their claim is also not against these categories. Full stop. Hence, we consider it para change unnecessary to consider the validity of selection of the candidates made in these two categories. Full stop. In other words, we confine our consideration to the validity of selection of the candidates made in the journal category. Full stop. Mainly the submissions made on behalf of the appellants were that after declaration of the result of the written examination on 1/4/1998, standard could not have been lowered for making other 40 candidates eligible for the purpose of interview. Criteria could not have been framed after declaration of result of the written examination. Maximum 21 candidates could have been called for interview in the ratio of 1:3 in the journal category on the basis of the merit of the written examination, whereas out of 78 candidates whose result was declared on 1/4/1998, more than 60 candidates from the journal category para change learned additional solicitor general and learned senior counsel for the respondents at the outset submitted that they have primarily objection for the very entertaining of these appeals and considering the contentions advanced on behalf of the appellants on merits having regard to their conduct. Full stop. According to them, the appellants made deliberate misrepresentation with regard to the allocation of marks, stating that 150 marks were for the written test and 100 marks for interview. Full stop. Further, malafides were attributed to authorities on the basis of the relation of political influence, which they gave it up before the High Court, but again reiterated in the SLP. Full stop. According to the learned counsel, these two grounds are good enough to dismiss the appeals by revoking leave granted without examining them on merits. Full stop. Although we find justification in these submissions, but having heard the parties at length, we consider these appeals on the merits of the contentions as well. Full stop. On behalf of the respondents, further submissions were made explaining the criteria fixed in what circumstances more number of candidates were called for interview and how the selection made was fair and proper. Full stop. According to them, mere calling more number of candidates for interview did not vital the selection made, having regard to the facts and circumstances of the case. At any rate, the appellants, being lower in merit, even otherwise, could not get any benefit. Full stop. According to the learned counsel for the respondents, the impugned judgment of the High Court is perfectly valid and justified. Full stop. They also submitted that pursuant to the selection made, the selected non-official respondents have been continuing in service since May 1998. That is, they are continuing in service for about 5 years by now, and as such, these are not the fit cases for exercise of jurisdiction under Article 136 of the Constitution of India to interfere with the impugned judgment and order.